Right. So we're going to talk tonight about getting repairs done and various strategies we can use to get landlords to make repairs, including legal strategies, organizing strategies, things we can do individually, things we can do as a group. Right. One sec. There we go. And if you have questions as we go, feel free to either put it in the chat or put your hand up or come off of mute and just ask the question. If it's a clarifying question, we can answer it in course as we go. If it's something that would take us down a different direction, there'll be a time for questions and answers at the end. Okay, so one word about the organization that I work for. TakeRoot Justice is a free nonprofit legal services provider, and we work with grassroots and community-based groups in New York City who are fighting against racial, economic, and social oppression. And we are proud that we get to work with Cooper Square and have and are great admirers of the organizing that Cooper Square does and that the tenants do with Cooper. So let's start things off. All New York tenants have the right to safe and decent living conditions, and that includes working appliances and fixtures, hot water, which the owner of the building must pay for, electricity, heat, and gas, extermination, repainting, fire safety, sanitary, trash storage and removal, clean public areas. That's not everything, but that's a list of some of the most prominent things that landlords have to provide. You also have the right to repairs, right? And that includes, by law, there has to be a 24-hour phone number. So somebody you can call in case of an emergency and be able to get a response. And that phone number has to be posted in a public space of the building. There has to be timely response to complaints when you need repairs. If your building has 9 units or more, there has to be a live-in super or 24-hour janitor services. Um, New York City also has laws specifically around safely removing lead paint and mold. And you're also entitled to have licensed professionals for the kind of work that can't be done just by a general super or a contractor like plumbing, electricity, carpentry, renovation. Now, I want to take a minute here as we go forward. I'm going to say a lot of things that the law says is supposed to happen, but you will probably notice that a lot of things don't always happen. Things even on this slide might be things that don't happen in your building. In fact, it's pretty routine for landlords to cut corners, to not provide these things. And these laws only exist in the first place because tenants have been fighting for over 100 years to have laws about decent living conditions and services. And even now, landlords don't just provide those things because it's right or because it's the legal thing to do. Tenants often have to fight for it. Okay, so let's look specifically at some of the the laws that govern the way specific repairs are supposed to be done. So mold in your apartment is a pretty common condition. And for many years, there was no law dictating how a landlord has to clean up mold. And they would just do anything from paint over it to sand it off to all sorts of things that could be dangerous. But fortunately, the city council passed the Asthma-Free Homes Act, and that includes rules for what landlords have to do when you have a mold problem. So first of all, the work has to be done by a mold remediation specialist licensed by the Department of Labor. So they have to have a license and they have to investigate and inspect the condition prepare an assessment and a plan and share that with the owner. The law doesn't require them to share it with us, the tenants, but we can ask for it. And a copy of the plan has to be kept somewhere in the building on site. They have to put up signs in the building saying that mold remediation is being done. If they use any kind of chemical disinfectants, they have to be approved by the Environmental Protection Agency, the EPA. And when they're done, they have to do another assessment, another inspection, and assess whether all the mold was remediated. So if you have mold in your apartment and you're not seeing these steps done, or if the landlord is just sending in a super to paint over it, or to knock a piece of the wall out and put in some new plaster, that's illegal, right? And the reason it's illegal is that number one, it could be dangerous to your health. And number two, it probably won't get at the root cause, the underlying water leak and the conditions that are causing the mold, and the mold might just come back. So how do we get landlords to do repairs or to do repairs the right way, right? So I'm going to talk about three tactics that we have: going to housing court, withholding rent, and if your rent stabilized or rent controlled, making a complaint to DHCR. Now, no matter what strategy you're using, the first step is always to document the problem. Okay. Notify the landlord in writing. Even if you don't have any faith that the landlord is going to do anything about it, it's still important to have the paper trail to show that the landlord knew about it and didn't do anything. Call 311 to get an inspector from HPD to come out and place a violation. And I know that also can be frustrating. First of all, sometimes you have to go around and around to get an inspector to come and to come when you're actually home. And then when they do come, they place a violation, and the violation, really nothing happens after they place the violation. The reason it's important to do this is because no matter which of these strategies you end up using, which of the three strategies we're going to talk about that you end up using to get your landlord to make repairs, it's going to be really important to have a record showing that a neutral party, right, an HPD inspector came in and placed a violation. So it's not just your word against the landlord's. Getting violations placed by HPD also starts the clock ticking, right? Every time HPD places a violation, there is a limited amount of time for the landlord to correct the violation. It's going to be either 24 hours, 30 days, or 60 days, depending on how serious the violation is. And if they don't correct the violation in that time, they can face fines, civil penalties, they have to pay money to the city. And so getting a violation placed creates the record, and it also starts that clock ticking so that the landlord is facing civil penalties and fines. And then finally, uh, depending on what kind of condition it is, make your own documentation. So take a photo if it's something that you can photograph. If it's something like the heat going out or hot water going out that you can't take a picture of, and it's also really hard to get inspectors to come at just the right time to catch those things. Your heat goes out, you call 311. By the time the inspector comes 3 days later, the heat's back on. In those cases, it's valuable to keep a log or a journal where you write down every time the heat goes out. You write down the time. You get a thermometer, just a basic thermometer that you can get at Target or the hardware store. Put it somewhere in the middle of the apartment, not on an external wall and not in the kitchen. Um, and record the temperature every morning and every night, or whenever is good for you, as long as it's the same time each day. And that can be used as evidence if you wind up going to court. So, notifying the landlord in writing, again, you may be doing nothing more than creating a paper trail here. Or it may be that your landlord actually will respond, and that's great. But when you notify the landlord in writing, you want to include a number of things, right? First, you want to include the date because, again, you're creating a record of when you told the landlord about the problem. You want to list the specific conditions. So on this slide, those are the three things in blue. You don't have to get really technical, but you should explain, you should say which room the problems are in, what specific thing isn't working or is broken. Um, give times that you can be there to provide access for the landlord to come uh, and inspect and do repairs. Ask them to respond in writing because you want as much of this communication as possible to be in writing, to be on paper. If the landlord's gonna give you another date that they're gonna come, um, HPD rules actually say that they have to give you at least a week's notice, right? So if they show up without notice or they give you a notice saying, I'm going to come tomorrow, of course, if it works for you, you can go ahead and let them in, and that's great. But if they haven't given you a week's notice and it doesn't work for you, you don't have to let them in. And ordinarily, refusing access to the landlord when they're trying to do repairs, it can be a basis for eviction. But again, not if they haven't given you at least 1 week's notice. Okay. Um, and then anything else that you want the landlord to tell you, whether there's anything you have to do to prepare the apartment, who's going to be coming, what they're going to do. Are they just going to come and look at it and then date another date to come back for the repairs? Are they going to do the repairs? What time are they going to come? How long should I expect them to be there, etc. Again, it's usually not the habit of most landlords to give you this information, but it's but that doesn't mean that you aren't entitled to it. Right? It's your apartment that this is happening in, and you have the right to have the repairs happen in a way that isn't harassing, right? Okay. So let's assume that you've sent the letter and you've waited and nothing has happened, right? So one way you can escalate things is to bring what's called an HP action. And HP stands for housing part. It goes all the way back to the 70s when there wasn't a housing court. There was just one part of the court that was the housing part. We have a housing court now, but the name has stuck. So this is a lawsuit that you bring in housing court. It's unlike every other kind of lawsuit that gets brought in housing court, this one is brought by tenants, and the landlord is the defendant. And what you're asking the court to do is to order the landlord to do repairs or to stop harassing you, or both. The pros and cons of bringing an HP action. The pros are you're on the offense, right, as opposed to when the landlord takes you to court for eviction and and you have to fight there over conditions. The worst thing that can happen in an HP action is if you don't win, nothing happens, right? So there's no risk. If you lose, you won't get evicted or you won't have to pay anything. It's possible to bring HP actions in groups. The law actually says that an HP action can be brought by a tenant or group of tenants. So this is a really good way to get neighbors and other tenants in the building involved. You can bring an action as a group. Um, this is generally the fastest of the options. Housing court moves relatively quickly. And landlords tend to respond. They tend to react when you take them to court. They show up and they want to come in and do repairs. Whether they're going to do a good job is another question. But if you want to get a quick reaction from a landlord, this I've found is the most effective way. Okay? And you can get a court order for the landlord to fix the violations. The downsides are you have to go to court. That takes time and energy. You have to take time off of work. Sometimes you have to be there all day. While housing court moves pretty slowly across the calendar, it moves moves pretty quickly across the calendar. It moves slowly when you're there during the day. And so you may wind up sitting in court all day. Um, if you're not protected by rent stabilization or rent control or good cause, the landlord might retaliate and not renew your lease. To be sure, that's illegal. That is absolutely illegal. And there is a law that you can use as a defense if a landlord is evicting you in retaliation. But nobody wants to be in that position where you're having to defend yourself, even if you have the law on your side. And finally, the way housing court works now, when you bring an HP action, you can't get any money. Um, the other strategies we're going to talk about, tenants can get some money as compensation for living with conditions. But the judge in an HP action doesn't have the authority to award money. All they can do is order the conditions to be fixed. If you want to start an HB action, you go to Manhattan Housing Court. And I'm going to be sharing these slides with Cooper Square, and they'll send them out to everybody who signed up for the workshop. So don't worry about writing down all of the details and the address and the numbers. You'll get a copy of this. When you go to the housing courts, you go to the clerk's window and you say, I want to start an HP action. And they give you some forms to fill out. And the forms are pretty straightforward, but you want to have this information ready when you go to court. You want to have the names and apartment numbers of everybody who's bringing the case. You want to know the names and the mailing addresses of the landlord and the manager of the building, who might be somebody different from the landlord. And you can look those up on HPD's website. All you have to do is type in your address, and you will see a lot of information about the building, including the name of the owner and their address. And finally, you want to have with you, obviously, a list of all the repairs that you're seeking. It costs $45 to start a case in housing court, but you can, if if you are low income and $45 would be a hardship, you can actually fill out an application and the court can waive the $45 fee so that you don't pay to start it. And then finally, one other thing to keep in mind is after you've filed the case, after you've gone to court and you've filled out the papers and they've been signed, and you've got a court date, you'll still have to serve the papers on the landlord. And that has to be done in a very specific way. And I won't go into it right now because that's a whole nother direction that could take us. And you'll get written instructions on how to serve them. But just to bear in mind that once you've filed it, you still have one step left, which is you have to get the papers to the landlord at the address that they've registered with HPD. So you get a judge's order to correct. And what good is that? If the landlord wanted to follow the law, they would have done the repairs in the first place. So if they're going to violate the housing code, why aren't they going to violate a court order too? And often they do. And so if a landlord or if anybody in any court case violates a court order, they can be held in contempt of court. And what that means practically is you go back to court, you fill out some more forms, you say the landlord violated the judge's order to correct. You get another court date, and if you will have to show that the conditions are still there, and the judge can use a bunch of tools in this case, including, in this case, giving money damages to the tenant. So I said earlier that you can't get money damages in an HP action, but you can if the landlord is held in contempt. And that's just something that's true for any kind of court, from the United States Supreme Court down to traffic court. If somebody violates a court order, the judge can make them pay. They may have to pay more fines and civil penalties to HPD. They'll get new deadlines set. If they don't meet those deadlines, you can go back and again contempt. And I have seen cases where people actually wind up getting 3 or 4 judgments for money over the course of a year, um, that'll escalate to try to give the landlord enough incentive to finally do the work. And though this is very, very rare, a person who's in contempt of court can actually be put in jail. And occasionally, maybe about once a year in New York City, it'll be in the papers. Some landlord will be held in contempt and actually put in jail. That's not the kind of thing you want to count on or expect. Again, it's extremely rare. It usually comes when a landlord has allowed such terrible conditions that a lot of people are in danger, and the landlord has been especially uh, contemptuous towards the court. But that is something out there that can happen. Okay. The second strategy we're going to talk about is withholding rent. So you notify the landlord that you no longer will be paying your rent until they do the repairs, right? Like an HP action, it's got pros and cons. The pros are that you're really using your power here, right? You're hitting the landlord where they feel it in their pocket, right? Your rent is the most powerful leverage you have. And the loss of that rent is a bigger deal to the landlord even than being taken to court, right? In addition, when the whole thing gets resolved and the work is finally done, you may be actually be able to get a percentage of your rent abated or deducted, right? As compensation for having lived in an apartment that was not up to code. The downsides are that most likely the way it will resolve is the landlord will take you to housing court with an eviction case for non-payment of rent, right? And that's where you'll fight it out, and you can win there, but unlike the HP action, you're on the defensive, so it's a bit more risky, right? And an important thing to keep in mind is that even if the judge does order that you get some of your rent deducted, you're still going to have to pay the remaining rent, right? So if you withheld rent for 6 months and you go in and the judge says, yeah, I think because of the conditions you lived with, I'm going to give you a 20% deduction on your rent, you still need to pay the other 80%. And which means that as you're withholding rent, that rent has to go in a lockbox, right? Whatever that is for you. You can put it in a bank account, you can get money orders and keep them in a locked drawer, whatever works for you. There's no rule that says it has to be in a bank account or this or that place. The most important thing is that it's safe, because when you get to the end of the process, you don't want to win the case and then wind up losing the war by getting evicted because you don't have the rent to pay. If you want to withhold rent, these are the steps to follow, right? So as we talked about before, all these strategies start with notifying the landlord in writing with all of that information and tell them that you are withholding rent until it's fixed. Uh, Not only should this be in writing, you want to make sure you get proof that they got it. So you could, if you email it, that's usually good enough. If you're sending it by mail, send it with return receipt requested, just so you have the paper trail and you can prove that the landlord was on notice. And then, as I was just saying, set aside all of the rent each month. Right? You may not end up having to pay all of it, but you may have to. pay all of it. You may pay a percentage of it, but it's hard to predict how much that will be. So you want to make sure you're safe. And when you're in housing court for non-payment, the one way to be safe is to make sure you have the rent. So if worst comes to worst and you pay the rent, the eviction case goes away, right? So you want to have that safety catch there all through this process. Now, if you get your neighbors together and a lot of people in the building withhold their rent, then it's a rent strike. And a rent strike is far more powerful than a single tenant withholding rent because it really hits the landlord in their wallet. And it's much harder for the landlord to retaliate against everyone in the building or against two-thirds of the tenants in the building than it is when you're fighting alone. So rent strike is an extremely powerful tool, and it's one that that tenants fought for decades, right? The laws that we have now that allow tenants to go on rent strike are only there because of the tenant movement, because tenants fought for decades to change the law to give us tools to fight back against landlords. Still, a rent strike is not something you want to go into casually. You want to make sure that everybody is in agreement, that everybody's on board, that you and your neighbors trust each other enough to be making decisions around shared money. And you absolutely want to talk to a tenant organizer and a lawyer so that you can go over, all of the risks, all of the benefits, and make sure you're doing the rent strike in both the safest and the most powerful way, right? So it's important to plan carefully and, even if it takes time to make sure that everybody's on board. The Right to Counsel NYC Coalition has a really great toolkit for rent strikes at that link. And again, these slides will be shared, so you'll be able to get that and click through. And of course, the organizers at Cooper Square have deep experience with rent strikes and would be happy to talk with people about, what it would take to start one in your building and how to do that. Okay, so the third strategy, we talked about going to court, we talked about withholding rent. This is called a rent reduction order from DHCR. DHCR is the state agency that oversees a lot of housing programs, but most importantly for us, rent stabilization and rent control. And so I'll say up front, this strategy is only available if you're rent stabilized or rent controlled, right? So this is a more limited strategy than the others. The pros and cons are, it's the easiest one to do. Everything is done by mail or online. You don't have to go to court. You don't have to take time off from work. There's no trial. Everything is on paper, right? It can lead to a small rent reduction, right? If DHCR grants your complaint, it rolls your rent back by the last lease increase, right? So it reduces your rent to what your last lease was until the landlord makes the repair. The downsides are it's the slowest of all three of these. DHCR has a huge backlog, and they're taking months or even over a year to process these applications, these complaints. And as I said, it's unfortunately not available to anyone except rent stabilized and rent controlled tenants. If you think this applies to you and you want to do it, and I'll say one of the best uses of the DHCR rent reduction is to do it alongside one of the other ones. And it's, again, it's so simple and easy to do. You can literally do it in about 15 minutes. It's a good way to augment what else you're doing. So again, as with all our strategies, first thing you do is you give landlord written notice, right? You make a demand to them. It's a good idea to call 311 and get HPD to place a violation because if there's a violation, DHCR will usually just defer to that and they'll say, okay, HPD found something, if found that there was a hole in the wall or mold or water leak, so we believe there is one. Um, and then you go to DHCR's website, and you can go right to the link here, and you fill out a form. And it's pretty basic. You give your address and your name and the landlord's contact information and name. You describe the conditions that you're complaining about. You attach a copy of the letter that you sent to the landlord to show that you notified them. And you can email it in or mail it in. And then you're pretty much done, right? DHCR will get it and they will mail a copy of it to the landlord and tell the landlord you have a certain amount of time to respond. Landlord mails their response in. And then usually what happens is DHCR contacts you because they're going to send an inspector. So they'll say, we're going to come on such and such a date to see if there's still a hole in your wall. And then they come. If they find the condition is still there, they roll back your rent, like we said, by the last rent increase. So back to your last lease. And your rent stays frozen at that level until the landlord demonstrates to DHCR that they fix things. And so usually the landlord will uh, send they fill out a certification, they send it to DHCR. DHCR contacts you and says, we got a certification that the landlord fixed a hole in the wall. Is that true? Right. And if it is, you do nothing and eventually your rent gets restored. So not a lot of money at stake here, but it is enough to kind of make the landlord notice. Uh, Definitely don't try to copy all this down. This will again be in the slides. These are very useful websites in gathering information when you want to follow any of these strategies. The housing court has an online calendar, and you can find out. They also have a lot of you know information about how to do things. And unlike a lot of legal writing, the housing court's website is actually pretty clear and helpful. Um, Acris is a website run by the City Department of Finance. Every time a property gets sold or a mortgage gets taken out or a few other things, it gets recorded on Acris. So you can put your address in there and you can literally see every deed, every mortgage, every government action that's happened to your property, which means also you can, if you only know your landlord as, the 123 Main Street LLC, you can look at the actual documents that they sign and you can see the names of the people behind the LLC. Because an LLC can't sign a mortgage, a person has to. There's an excellent website, or actually tool, from an organization called Just Fix NYC. And they have tools to help you request repairs from your landlord. They can actually help, they can generate a letter for you to send to your landlord. They can help the app can help you make a 311 complaint. It can help you file a rent reduction complaint with DHCR. And then they've also got this app called Who Owns What, which gathers data from all kinds of different city databases and gives you just a ton of information about who owns your building and what else they own. And it's not fail-safe, but it's a really good place to start to find out not only, who your landlord is, but what else they have going on. Um, you know, what are the names of the people behind the LLC that you've never met? What else do they own? Where might you be able to find other tenants who are having the same problems that you are? HPD's website, you can search by your address. It'll show all the code violations. It'll show every complaint anybody's made. It'll give you information about who owns the building, um, and a whole bunch of other, stuff that may be interesting depending on the situation at your building. It'll tell you whether HPD has ever sued your landlord. It'll tell you whether your landlord owes money to HPD. Department of Buildings, similarly, you can look it up by your address. You'll be able to see all the building code violations. You'll be able to see all the permits that the landlord ever applied for, anything that was granted. You'll be able to see if they've got a permit right now. You may be able to see the certificate of occupancy for your building. DHCR website has all the forms that you need in order to make a rent reduction complaint and some other things that are beyond what we're talking about tonight, but things like rent overcharge complaints, or succession claims if your rent stabilized. And then the Right to Counsel NYC Coalition has a ton of information about housing court, which you may be going to if you use the first two strategies we talked about. And also a lot of resources for tenants who are interested in organizing, or being part of the larger tenant movement. And then finally, I didn't put it here because we have them live on the call. Cooper Square has been doing all of this for, they'll have to correct me, 60 years, I think. And so just being on this call and being on a call with Anna and Cindy, is actually the best step you can take, no matter which strategies you go on to use.